Hi everyone, welcome into Life and Law with Debora Diaz. I am Barbara Marville Kelly. Thank you so much for joining us. Deborah, we're back again.
And I'm Debora Diaz. Thank you for joining us.
Yes, we do have a lot of questions that have been coming into us that we're going to cover today. Since we started the show with you, we have talked about just about so many different topics and talking points, and our viewers have questions, whether it be for themselves or maybe a friend or a relative, so we're going to jump right in. But before we do that, in case you're new with us, I just want to let you know that Debora has the caring, the compassion, and she's very courageous as well, and she's available for you to speak to directly, and I love that direct connection with you. So one of the questions: can I change the amount of child support I pay to my ex-wife? If so, how can I do that?
Okay, it's a possibility that child support can be modified.
Okay.
I'm assuming that this person has a final judgment. So let's say, because that's all the information we have. So we have a final judgment and an agreed upon amount of child support. So what the person needs to review is what's changed since the entry of the final judgment. Has the wife's income gone up or down? Has his income gone up or down? So what are the reasons why he wants to modify it? Right? Is there a change in the income? So you want to look at, is there a change in the income? And if there's so much of a change, at least 25%, you can go in and file a modification. This is to modify the amount of child support being paid.
Okay.
But there has to be some reasons. It has to be supported.
Documentation. In other words, you can't just go and...
Both parties will have to submit financial affidavits.
Got it.
And that's what look at. But it really is a good idea to go have consultation with an attorney, bring the final judgment, the order, let it be reviewed, and then can get a good idea what the person is looking at up or down in child support.
So depending on what kind of documentation comes in to validate these questions of wanting to change this, how is there some sort of a generalized time frame? Especially if someone's income has gone down, they're already struggling.
Then they should act right away.
Okay.
Because it's any change. So let's say there has been a drastic, and this can happen if someone's laid off.
Sure.
Or some other way he loses a job.
Okay.
Then what you want to do is make sure that that it's going to be justifiable.
Okay.
All right.
Okay.
So.
Well, that makes sense, and that's good to know in case anybody is in that situation or you find yourself in that situation. Can I modify the parenting plan for my children? Is there like a statute or a law that says it has to remain in place for X amount of time, or can somebody?
Oh, no, of course not. No, parenting plans can definitely be changed.
Okay.
They can be changed, but again, one of the things as far as when we litigate and when we have a final order is that the court's like, the end to things. You don't want to have to keep going into court. So the reasons, why is the parenting plan, why does anyone want to change, either parent, why do they want to change it? What has happened? What has changed between the time the parenting plan was agreed to and signed and approved by the court to that would make that it has to be changed now? What are the reasons? Okay, so maybe there is a change in the school schedule of the child. Maybe the parents' work schedule had changed. But always first, yes, it can be changed, but you are co-parenting with your former spouse. First, it's a good idea is to try and have a discussion. Can it be? If there's some little modification, can they change it? And if they can agree to it, they could write it themselves and it should be in writing and agreed to. If they can't get an agreement, then I'd say the last resort is that you have to go into court to try to change it.
So once they make the changes between themselves and they're in full agreement, is that something that has to be submitted to the court?
They
or can
submit it to the court.
Okay.
They can submit it to the court to be approved as an order.
Okay, very good.
As part of a
very good.
order.
This just raised a question in my mind about the age of children and what age they're able to decide whether or not they want to be with one parent or the other.
That's a really good question because that's a common thing. There's a misconception I will get many times, and many times I overhear conversations, or someone will ask me, well, my child is 13 now, and I heard when they're 13 they can decide where they want to live, or some variation of that. And that really is not true. Okay, there's factors in the statute that the court looks at, and it comes down to the best interests of the child. So among all the factors between the parents, emotions, psychological, the home life, stability, among some of the factors that the court will look at to decide the best interests. So it's not so if the court feels now say we are dealing with a teenager, the courts don't like to do this, but if possible, to have some testimony by the child, really outside of the court. It's called a motion in camera, which means it's just the judge and the child asking answering the judge's questions regarding why do it change. So so children can have some input at a certain age, but it's not something that the courts really want to be out there encouraging and saying, because think about this mess that we would have if parents are bringing in their children to try to litigate the issue of should we
they're not mature.
They're not really, and we know too, we can say this as an aside, I mean, teenagers, okay, they have their own mind. So we might have had so why does the child want to change? Is it some of the teen stuff that's going on, thinking that maybe it'll be rosier with the other parent? And so we're going to look at the whole picture.
You're stirring up more questions. So when let's say you have two teenagers, you have one teenager living here, one teenager living here, and the one separately,
okay.
Yes, with each separate parent. There's only two children. The one is being disciplined and going through the whole, parenting, effective parenting. The other one, there might not be the kind of effective parenting or any disciplining at all, which appears to be possibly causing some behavior challenges. Just what comes to mind is there some kind of outline, like what each parent is supposed to do?
Are they?
And you're just making this up. I'm just making this up.
Yes, but are you saying that the two children have the same parents? And so one is, they're each with one of the, okay.
Yes.
Of course, that's difficult. And probably one of the reasons why the parties are divorced, because that they had different ideas.
Yeah, very good point. Very good point.
But you really should try to be on the same wavelength, the same page as far as what's going on with the children through open discussion. But really, one parent can't force, the other, on a particular discipline method. So a way to try and handle that is to try to be talking the two parents. Again, there should be co-parenting the children to try to talk about it. If not, maybe trying to go to a parenting coordinator, or
I see. Okay.
Or, there's some other options to have, discussion with a counselor.
Yeah.
Maybe there's a happy medium. Maybe there's some compromise between the two ways. Because I understand that would be difficult. Two teenagers, and say mom's doing one thing, dad's doing one thing, and
right. And so when they have their planning time with the one parent, it's very difficult, and they don't want to be there because they are being disciplined, which is a good thing, especially with teenagers. And so it's conflict. And when you can't have a resolve with one of the parents, and it continues to go on to the point where it appears to be affecting the child's emotional and psychological, all of that, what does the disciplining parent do? Do they, as you say, try to work that out? I love the idea of a parent coordinator. So that it's as soft.
Could submit. Sometimes you just need that third party to add a viewpoint to the situation.
Yes. Very good. Very good. That okay. All right. We've got a couple of minutes till break. Okay. My husband and I share our two children. I have been having the children more times every week. I pay child support to my husband. Can I reduce the amount that I pay him?
Okay, so I think what they're asking is because they had the time sharing schedule is going to change in the summer.
Okay.
I believe that's what the
Okay,
is.
okay.
So now that they, let's see, yes, okay. Well, probably not is going to be the answer to that. Your original time sharing plan was calculated, and the child support was calculated on that amount, keeping in mind that those summer visitation and all the other time sharing that the parents are going to have.
Okay.
So it is not something that most final judgments will say that the amount of child support that's ordered continues no matter where the child is during this whole time sharing.
I see. So-
Because it's viewed as this whole yearly
picture,
period
a
of the
full
year
picture.
and so that it works out, and hopefully it was based on one parent having the time and one parent not having so much time.
That makes sense, and I can understand the question too, because if one is
Many
picking up more
times.
of the load, more of the cost and
They
everything.
believe that maybe I shouldn't be paying this,
Yeah, yeah.
time.
That's
Exactly.
easy.
But it's viewed as that it's going to even out.
It will even
works
out in the end.
Yes,
Exactly.
yes.
Okay, very good. We're going to take a brief little time out. This show goes by very, very quickly. Thanks for
Okay.
being with us. We'll be right back after this.
Revolutionary in his field, Dr. Bonatti created, perfected, and patented the Bonatti spine procedures. Using his genius, Bonatti invented precise tools necessary to minimize surgery, scarring, anesthesia, and recovery. So successful are the Bonatti spine procedures, they consistently reflect 98.75% patient satisfaction. 50,000 successful procedures have been performed exclusively at our location. Over half our patients have suffered from failed back and neck surgeries at other facilities. Bonatti succeeds where others fail.
Hi, everyone. Welcome into Life and Law
Welcome
with
back.
Deborah Diaz. I'm Barbara Marville Kelly. Thanks for joining us. Some really good, serious questions that we have here with pretty easy to understand answers from Deborah. So we've been talking about child custody and, modifying the program for parents.
Questions?
So another...
Before we go on to
Yes,
that,
yes.
I wanted to.
Oh, you wanted to back up a
I wanted
little
to
bit.
back
Okay,
up a
good.
little bit
Okay,
because I
good.
want to go back to our child support question
Yeah.
because I kind of had lost my little bit of train of thought there on what I was trying to complete.
Okay.
And it's about filing the petition and about if someone knows, say they've lost their job and their child support needs to be reduced. This is one of the things why I was trying to emphasize to do it as quick as possible because there will be no retroactive reduction.
Oh, I'm glad you went back to that.
So the child support arrears. So let's say the person has to pay $1,000 a month, okay?
Yes.
And his income's I'm going to just say him, make an assumption. His income's drastically reduced and to half of what he was making before. So there's going to be a reduction.
Yes,
okay,
yes.
so let's say it's reduced down to $600 a month. Okay,
Right.
well that he's going to still be, and the petition's not filed for months down the road. All that time while it's pending, or before it was pending, before he filed it, his arrearages is accruing. So he's being charged with $1,000 a month. So that's why if you are facing a reduction, a job loss, don't wait. And this is what I see people doing. They'll wait for a year later and trying to say, well, my ex-wife knew I lost my job, or she knew I was laid off, or that I had less, finances. Well, that's not going to help because the time for the reduction to be is once the petition's filed. So you file a petition for modification of child support. So let's say it's filed June 1st of 2017, and maybe the case isn't heard for 6 or 7 months down the road.
Oh, yeah.
The
yeah.
retro then, and say the person prevails, the retroactive, it will go reduced from the June 1st date, the date the petition was filed,
Right,
versus
not the
down the
not
road.
the actual effective
Not the
date.
official. So
That's
why
that's
it's-
good to know.
That's why it's important that you are facing a reduction, that you file it as soon as possible, so that it can be heard. But more importantly, so that you toll, meaning stop, the larger arrearages
Yes.
from accruing
Yes.
on the child support.
So
I'm
you're-
trying to do a lengthy,
Like a lesser
understandable.
loss?
A lesser loss if you have to. You don't want this. You don't want to be charged with $1,000 a month and have a $6,000 child support arrearage amount.
Right.
When really you should have only been had to pay $500 a month.
Yes, yes.
Okay.
So hopefully you understand that.
So
I got it.
the takeaway is act quickly.
Yes, yeah.
Okay.
As in
Not to-
anything.
as in
anything.
Yeah.
Review
Get
your
in, talk to
documents.
somebody and- yeah.
Yeah, okay, well, that's
Okay.
good. All right, relocation. I am divorced. I have majority time sharing of our 2 children. I want to move to New York where my parents live. Can I move to New York?
It could be yes, and it could be no. She could. Okay. No.
Okay.
So not to make light of it, but first of all, we need to look at, what does the final judgment say? Most of the time, a final judgment will say, either something that, no relocation, or that they have to, or there might be already a provision in there in how they're going to discuss, or how the ex-spouses are going to discuss a relocation. But if it's silent, then the person that desires to relocate is going to have to talk to their former spouse. So first, if the former spouse agrees to it, you're not going to have an issue. You want to have it in writing and a modification about the relocation, but agreeing. They're not. Then the person that desires to move is going to have to file a notice and put the other parent, ex-spouse, on notice that they're desiring to relocate. And why? Okay, it's not good enough just because. Okay, it has to be. Is it a job? Is there more family support there? Is the income greater? Is an advantage? So what are these interests? Is it best interest not only for the parent that wants to move, it's the best interest for the child.
Yes.
So is this a good thing? And then if so, the parents, so we're assuming parents can't agree, then there'll have to be a hearing this relocation petition of the person that desires to relocate,
Based-
giving evidence, the reasons why, and at that point it's going to be so if it's for a job, you have the job offer, have it in writing, have the salary, do the research. How is the housing market there? Is it more affordable or less affordable? How are the schools? Are we talking if they grade them? Are we going the children are going to be in A schools or B schools? So how are the neighborhoods? What's the family? Does the parent that's moving going to have a whole support system in place with other family available? So again, it's looking at this whole picture of why the move, and then the court, if the parties can't decide, would make a decision on whether the parent is allowed to relocate. Now, if the court may say, okay, the parent can relocate, but something else is going to have to happen with the child or children, depending on what we're looking at here. I mean, maybe the child, it would have to be changed. Maybe parent that's staying behind has majority time sharing, and parent that's moving has lesser time sharing. That might be a possibility. And who's going to pay for the transportation?
Well, exactly. There's
that's
so many
the other
variables
issues.
here.
Yeah.
So basically what I'm hearing is if you happen to have been the person to ask this question, ask yourself what is important for the best interest of your child, and what you need to do as far as building that case for to get a yes
Having
answer.
evidence. It's not going to. It's not good enough to say I want to move there because
Right.
my mother lives there.
Right.
That's not going to be good enough. If it's litigated, that's not going to be a good enough reason.
So in other words, have a list that makes a lot of sense for the best interest of your child, and then maybe that is going to be better than you going in with, well, I just want to move there, my parents are there. So you're really saying be very, very pragmatic with the reasons of why you want to move. I've heard that there were some people that I know in Florida that they moved. They had 2 kids. And one of the parents had to move back because the other parent was not happy about all that based on the court decision.
Okay.
So
And that's entirely
possible.
That's entirely possible.
right, so do your homework basically.
It's do the homework,
Yeah.
knowing why.
Yeah.
Again, the cost of transportation is a biggie, and what are the methods? Are there a lot of methods? One of the relocation cases that I had a time ago, the one parent lived in Florida and one lived in let's say Tennessee or something like that, okay? And so they were co-parenting. And so the parent that lived in Florida would go to Tennessee to visit, okay? So parent in Tennessee now wants to relocate to Illinois, and not that far. So after doing the research, the number of flights and ways to get to the new place was actually easier than getting to the place in Tennessee where the other parent lived.
No kidding.
Okay, so even though person in Florida was fighting this relocation, it wasn't more of a burden on that person for the relocation.
I see what you're saying.
It actually was. So the court pretty much got the idea this person that was contesting was really contesting more just because. It's because the person's here, mother's already out of state, and really the time sharing would have looked at least on the evidence that it was going to be easier. Cost-wise, there were more flights there, more air lines flew to this location.
And that is
So
something
all
to
of this is
consider.
this is what goes into this research and building the case.
Sure.
When you have a litigated relocation case.
Sure. And I mean, think about it. It's worth it. It's your family. It's your child. So it's worth it to do.
It's definitely
all
worth
that.
it that, to go, if someone's thinking about this, to go and have a consultation with an attorney and talk about, and they'll get a good idea then of what's necessary.
Setting yourself up for success in this really is what it comes down to, in the best interest of the child.
Yes.
So, alimony. In a 12-year marriage, I want to get a divorce. Am I going to have to pay alimony?
Oh, excuse me, I didn't hear. So what did you say?
Alimony.
It was a 12-year marriage?
In a
Okay.
12-year marriage, I want to get a divorce. Am I going to have to pay alimony?
Well, without more.
I know, I was just going to say.
Without more. Could be a possibility.
Yeah.
Okay, so
Yeah.
we have a 12-year marriage. Under Florida law, a 17-year marriage is presumed long-term, meaning that there is a presumption that there should be permanent alimony if there's need and ability to pay. So we're talking about here, this person, 12-year marriage. So the presumption for permanent alimony is not there, but it could be one of the forms of alimony awarded. One of the, so let's talk about the forms of alimony. We have bridge the gap alimony, which is bridging the gap between being a married person and a single person. So maybe you need so much money a month just to bridge that gap as the other person gets on their feet, living a single life. So that's bridge the gap. Then there's rehab alimony, rehabilitative alimony, and people ask for that. And that is maybe we're talking the person has an associate's and wants to go on and get a bachelor's, maybe in nursing, okay, or some other type of program. What's going to be important is the rehab, meaning rehabilitating to some other career. Is there a plan? Okay, the court's going to want, if it's contested, the court's going to want to know, the duration of the schooling, what exactly is the degree that's going to be attained, what are the job opportunities. So let's say someone is going to say RN, okay, be pretty just, we're going to look, what are the employment possibilities? What can this, is it better? So it's got to be an improvement, okay? And the other type of alimony is durational alimony, which would be applicable, which is duration. So we have a 12-year marriage, so the person could have to pay the amount of alimony or the length of the term of the marriage. So I said that incorrectly. What I mean, will not pay any more than 12 years.
I gotcha.
The court cannot order more than 12 years if it's under the durational alimony. So it might say for the next 12 years you have to pay so much in alimony. And there can be temporary alimony too, which is kind of a form of, could be considered bridge the gap too, but temporary, maybe just for a year, get some alimony again. And there can be lump sum, which is a payout or a lump sum for now between that. So the question is, yes, the person could pay alimony, but it's going to be based on need and ability to pay, which is, and we can talk about that
I see.
at other times, but need and ability to pay.
Now, when you say ability to pay, even though one may earn way more than the other, the ability to pay is
We'll talk about that when we come back.
Time for a break. I know we do. Thanks. We're going to take a break. We'll be right back, and we'll pick up on the rest of that question.
Revolutionary in his field, Dr. Bonatti created, perfected, and patented the Bonatti spine procedures. Using his genius, Bonatti invented precise tools necessary to minimize surgery, scarring, anesthesia, and recovery. So successful are the Bonatti spine procedures, they consistently reflect 98.75% patient satisfaction. 50,000 successful procedures have been performed exclusively at our location. Over half our patients have suffered from failed back and neck surgeries at other facilities. Bonatti succeeds where others fail.
Hi everyone, welcome into Life and Law with Debora Diaz. I'm Barbara Marville Kelly. Just before the break, we had a question that we were discussing about alimony in a 12-year marriage. And this person says, I want to get a divorce. Am I going to have to pay alimony? Which was a pretty loaded question. The answer could be yes or no.
Loaded question.
So if you could just recap what it relies on and then key in on the ability to pay.
So let me just summarize a little bit what I did. If you missed the first, we talked about lump sum, bridge the gap, durational, permanent, and temporary. Those are different types of alimony. This case, short-term marriage, meaning shorter than what we have a definition of 17 years as long-term marriage in Florida. So permanent alimony most likely may not be ordered in this one, but all the other forms are out there to be awarded based on need and ability to pay. And need is after all the assets have been divided, so we have the equitable distribution. Then we're looking at the child support that's awarded if there's children. Then looking at the party's financial affidavits. The party requesting alimony, what is their need? After looking after legitimate expenses, household expenses, what is going to be their, do they have a need? Do they have a deficit? What is their need? So the first question is need. If there's no need, there's not going to be any alimony. So let's say so now we have the need. The party has shown a deficit. They have a need. Then we're going to look at the court. The next part of that is ability to pay. Does the other party with their assets, after they're paying child support, and after allowable deductions, do they have the ability to pay? Okay, and then if that answer is yes, then the court will look at setting an amount, which the two sides, I'm sure, will be presenting evidence as to why or why not, and the factors that the court looks at is one of the factors is lifestyle, standard of living, that's not a all-encompassing, that's the factor that decides. It's one of the factors that the court looks at. Did the parties go on vacations every year or not? What was their lifestyle? What's their the housing? What are their the automobiles? Is there a college savings? Were they planning for the children? And it all looks as to what was the lifestyle here, and is it realistic? Should the spouse requesting alimony be awarded some amount that might not replicate the complete lifestyle that they had, but bring some level of equalization? And that's not the intent of the statute, but we don't want one person to be destitute and one person is very wealthy,
right?
Too. I mean, our public policy is that nobody should be on public assistance, basically. As you look, should be because of their because of a divorce situation.
This may be a really crazy question, but does it matter who asked for the divorce in this instance?
No,
it does not matter. Okay.
And again, and I'll refresh and talk about that. It doesn't matter because it's a no-fault divorce state. In some states, it does matter. It does matter, but as long as, again, there's no fault. So because you want a divorce doesn't mean, okay, well, you're going to have to pay because you want it. Okay, that's not the state of the law.
Or based
the
on, there's so many variables. I'm glad that you're breaking this down so that our viewers
talk in smaller topics.
Yes, kind of in smaller, easy to chew bites, I guess you would say.
Well, not being familiar with the terms, I have to take in, I've been doing this for 22 years.
That's right.
So the terms,
That's right.
I always have to step back and say, what does, someone, what don't they know? Right.
And it makes a whole lot of sense. So anything else on that question that you can think of?
Highly litigated, alimony, it's going to be highly, I talked in a previous show that we've had many calls for some alimony reform, and so that we can, as attorneys, also have a guidance to this, because unlike in child support, we have guidelines. We can put in data, meaning income and costs and parties' legitimate deductions, and come up with the guidelines of what the child support should be for 1 children, 2 children, 3 children, and come up with an amount. Not the case in alimony. That we don't have something to say that we know that if you make this amount of money, you will pay this amount of alimony. We can't do that.
Okay.
We could say it's based on the evidence, the law, and when we go to court and argue the case and present the evidence.
Yes.
And so that's why people are talking, one of the reasons of having some alimony reform, that because the awards vary of alimony from
I would
one
guess.
it's because it's going to be
Sure.
individuals, there aren't guidelines. They're going to vary by the evidence that was presented in court.
Of course.
So
no cookie cutter.
Exactly. So two couples might think, oh, we have identical, and they have just such varying amounts of alimony because we don't have guidelines.
Oh, that makes sense. All right. Here's a good one on alimony. Alimony is a big topic
Alimony is
here.
always a hot topic.
Yeah. So this person has been paying alimony for 10 years to his ex-wife. I'm going to retire soon. Will I be able to get the alimony eliminated because my income is going to decrease?
That could be a possibility. But again, we're going to look at what does the final judgment say. So go back. Was it envisioned that the person was going to be retiring sometime down the road? What is the salary difference? Is it really large, or maybe just because you retire might not be? I mean, the CEO from Ford I believe is going to be eliminated. He's, his salary last year was $19 million. So his retirement, he's not really losing anything. No. But not to make light of that, but it means that it's a fact specific. What, and what is the person's income going to be that's asking for the reduction? And you can file a petition for modification. And if there is a change, and again, I'm saying you can file a petition if it doesn't say, because some final judgments do say that this amount of alimony awarded is absolutely non-modifiable. Some judgments have that. Final orders will say non-modifiable, and maybe because the person accepted a lesser amount, maybe that's receiving it, to agree, okay, then I'm not going to go in and ask for more. And the person that's paying agreed, I'm not going to go in to ask to reduce it.
Right.
So if it doesn't say non-modifiable, then there's a chance, go in, file the petition with the appropriate documentation. And it's not going to be, it has to be that there's been a change in the need. And
again, if you're going to be retiring on a certain date, I would just get right on it right away.
Maybe you're going to want to get it done as soon as possible.
Yes. Okay. All right. Thanks for that one. A 5-year marriage. I have been employed for 7 years with a large hospital chain. I have a 401k that I contributed to since I started. Is my wife going to get my 401k? That's a good question.
Okay. So 7-year marriage? You said?
5-year marriage?
5-year
Or 7
marriage.
year, no, sorry, yes, 7 years, yeah.
Okay, but only accrued the.
Oh, no, excuse me, I apologize. 5-year marriage, 7 years
So 2
employed
years,
with a
okay.
large chain.
Okay,
hospital
so
chain.
so assuming then we have, so the timeline is, starts work for employer, is accruing money in the 401k, 2 years later gets married.
Mm-hmm.
So we have 2 years that are non-marital contributions. We said it's a
Okay.
401k, so
Okay.
non-marital.
Okay.
Then we have going into 3rd year of his employment at the corporation and his 1st year of marriage, so those years. We have, that's marital efforts. It's marital funds now because going back to the definition of Florida's a equitable distribution state.
Yes,
Meaning everything,
yes.
Accrued during the marriage is marital. So
Okay.
this is, so the fruits of the marriage is employment.
Yes.
Some of that money was going into the 401k.
Right.
So the dispute's going to be, what's the value from the 2 years to the 5 years? So we have 5 years marital, 2 years non-marital
Non-marital.
funds.
Okay.
So how much, the portion, what was contributed in that, and then the values, and this is where you're going to use an expert to,
okay.
if we're
Okay.
talking, we want to get it specific. If the parties can't agree, that we have some non-marital value here, and they
Yes.
can't agree on as to what that amount should be, then we're going to have maybe a battle of the experts, or one expert, if
Right.
they both parties
Right.
agree, to come up with this amount that would be non-marital. Okay, so the wife is entitled to, if it's wife or husband, I don't know who is entitled to some of the 401k, but not all of it.
Okay.
the bottom line.
You just triggered a question for me on prenups.
We're going to break.
We're
I
going to
think.
break though right now.
Right, I think we'll be right back.
Revolutionary in his field, Dr. Bonatti created, perfected, and patented the Bonatti spine procedures. Using his genius, Bonatti invented precise tools necessary to minimize surgery, scarring, anesthesia, and recovery. So successful are the Bonatti spine procedures, they consistently reflect 98.75% patient satisfaction. 50,000 successful procedures have been performed exclusively at our location. Over half our patients have suffered from failed back and neck surgeries at other facilities. Bonatti succeeds where others fail.
Hi everyone, welcome back into Life and Law with Debora Diaz. I'm Barbara Marville Kelly. I'm going to jump right into
watching.
this. Yes, thank you so much. I mean, I'm learning so much, so thank you for questions that are coming in. We were discussing alimony, we were discussing 401k, and I had started to pose the question, can one in a prenuptial agreement prior to marriage protect their 401k in the event of a divorce down the road?
And that's absolutely yes.
Okay.
That is one. At that point, if you are considering, this would have been you were considering before you're married as the prenuptial, you're going to say that both parties can segregate out their 401k specifically.
Okay.
I mean, they can be, a prenup can really address whatever it is you want to. So 401k is one of the things, one of the assets you want. You can say, you know, everything when I'm accruing my 401k, it stays non-marital. It's viewed non-marital. And you can, and if both, and party signs, that is a legitimate agreement with full financial disclosure. The other party agrees to it, that's, yes, that is one of the things.
Perfect.
Even after a marriage at some point, which is then we get into what's called a post-nuptial, if the parties are having decisions and if the other parties, the spouses are having a discussion and both spouses agree, they can agree to it then too.
Oh, okay.
You can have a post-nuptial agreement outlining what assets would be non-marital and separate.
I see. Very good. Thank you. All right. My girlfriend just had our baby a few weeks ago. She will not let me see my daughter. What can I do?
That's a common.
Now, they're not
like
saying married or not married.
It sounds like that. I'm going to make this without more information that they're not married. So we have that, and so the mother has baby, and now father wants to see the baby, and under if there is, I'm working an assumption, there's nothing in place, so paternity has not been determined yet. Okay, so the natural guardian, okay, under our laws, and natural controlling parent, let me use that word, is going to be the mother.
Okay.
So the mother right now at this point with nothing in place has 100% of the rights, meaning anything with the child, she can leave the state of Florida without asking the father permission.
And that's
because
without
there is nothing.
paternity.
I'm talking about there's nothing in place.
Okay.
We don't have an order. We have nothing that says, this person that is the father of the child. Okay, so what the person needs to do, that's the father, what father needs to do if he's interested in and wants to establish paternity, that's what he has to do, is file a petition to establish paternity. Can admit there's certain allegations that have to be in there, but can admit, or saying, I believe that I am the father, I will, take the DNA test and pay, and what you're asking for, because why these cases most of the time get to the court, the mother might be disputing, saying, no, he's not the father, maybe she had several sexual partners, or not, say, no, he's not the father. So the court has the ability to order DNA testing, and order, mother to provide DNA or the child and take DNA testing. But until father's not going to have any rights until that petition is filed And then as that petition's pending, he could file for some temporary relief, meaning asking to at least have some time sharing with the child while the case is pending. And that's one of the options. But as the case is, until the court makes an order, and once, and if he is the father, he will get time sharing, okay? So when I'm advising, when I have a mother coming in to see me, an unmarried mother with a child, and saying, I don't want my ex-boyfriend to see, the baby. I don't want him at all involved in the child's life. And she can't give me any other reasons than that, that she doesn't want him involved. I'm saying the father will have some involvement in the child's life. The court will order time sharing. So this is our philosophy is both parents should be involved with raising the child.
Unless there's some kind of extenuating...
If somebody's coming to me, I'm going to say, come to an agreement. Let him see the child. Let them see, and if they're not comfortable because then they're afraid something's going to happen, then have it initially that they're seen, at a mutually agreeable person's either home or some other third-party place that they can feel comfortable, so that there is some communication.
Okay.
But father won't have any rights until the court decides, until a petition's filed, a court determines, through testing that he's the father, and then he will get rights and time sharing.
Makes a lot of sense.
And probably, and that's when child support's going to be determined. Okay. And what's related to this, I should say, is that child support and paternity under a state action are totally, they're not related, meaning that many times there's actions on the Department of Revenue. Mother goes in, says father's not paying child support, and orders, and just by showing financial affidavits, send some information to the father, father fills it out, court, and so an amount of child support is ordered, just child support. Sometimes the father thinks that he has rights because of that. He doesn't. Department of Revenue only deals with child support. He doesn't give him any time sharing. In order for him to have time sharing, he's going to have to still file a petition. At that point, he can say admit paternity again and say, we have this Department of Revenue action, had the child support, but I want time sharing. So time sharing is a separate action. Under the Department of Revenue. I wanted to get that clear because people have this misconception. They think, oh, well, I'm paying, a lot of times too, if the male's coming and saying, well, I'm paying child support, but she won't let me see the child. I'll say, well, let me look at everything that's there. And it only is a Department of Revenue ruling that says he has to pay child support. It hasn't dealt with the time sharing, the parenting issues. Okay, it's not set up. The system's set up to get the child some money, not to get the child time sharing.
So this is more reason to acquire legal counsel. Get all your ducks in a row so nothing is left out of the loop.
We're running issues, I know.
Right, because you've been doing this for 22 years, so it's like be prepared. Follow the Boy Scout model, be prepared, and things may fall into place a little bit more stress-free, I should say, if there's such a thing. We're running out of time. 5-year marriage, Debora. Oh no, we covered that one. Excuse me. I'm so excited about answering all these questions. Okay, I am thinking of getting a divorce. I heard about collaborative divorce. What is collaborative divorce, and should I consider that?
Okay, I'm going to just give the quick on this one, and then we'll spend a show and a more in-depth. Collaborative divorce is a team approach to getting a divorce. Definitely should be considered. I'd like to present a lot more information on that. I'm a collaborative divorce practitioner.
Okay, good.
But what collaborative is the parties are going to have a team going into the divorce, a financial planner, a mental health counselor, their attorneys, and they sign an agreement that if they don't have an agreement, the attorneys sign an agreement, everyone signs a participation agreement, but if parties ultimately don't reach an agreement, the attorneys that represented them in this collaborative divorce will not represent them in litigation. Okay. But we need to talk a lot more about this collaborative divorce, and which we will in other shows. But to answer the person's question, should they consider it? That answer is yes.
Yeah, why not?
Consider it, look at it, and see if it's if it's versus litigation, if it's a method for you. Okay. All right.
All kinds of options here. Okay, we have covered these questions, I believe. Is there anything else you
We
can
were
think
just
of?
gonna, yeah.
We were going to talk a little
We're
bit
gonna
about
talk
some of the
about
tips
just-
for
we were
summer.
just going to say with summer coming
safety.
up, end of the year, summer safety, made me think of Memorial Day here coming up with fireworks, and to say that to really be careful with the, children are out of school, so be careful with the fireworks out there too, meaning I know that necessarily being out of school Memorial Day is not related, but it's the issue of these fireworks that are out there, and every year we hear about accidents, so really be monitoring those. Okay, they're dangerous, they really are, so monitor that, any kind of usage with that. Monitor the pools. This is another thing. Florida, we have most of the time year-round swimming, but every year we hear about drowning, so we really need water safety. So be extra vigilant with more children with more time on their hands. Be extra vigilant around the pools, the ponds, everything. Watch those, because I know within 5 seconds a child can disappear.
Well,
so
exactly.
Watch
Exactly.
that.
Get lessons. Get
Watch
lessons
the
for your
sun.
kids.
Yeah, but the sun. Be careful around the sun. It's so
my
easy.
goodness.
The other day I saw this little baby in a pool, and they were visitors, and I could tell, and the child was in the pool, no hat on, a little baby, and the sun is so strong here. So that's just another tip of just be cognizant of that with children. Be cognizant of heat stroke, and when you're driving, put some kind of reminder if you have your children with you in the back seat in a car seat to make sure, because we don't want to keep read about a baby left in a car.
Oh my goodness, that is so true. I'm really glad that you suggested doing some summer tips, because even though, yes, we are kind of like all year round summer
like
and
we're
swimming
year-round,
and
but
things like that, it's nice to have those reminders for you, because we do have Memorial Day weekend coming up this weekend for us. And then after that, it's summer. Think about a protect a child pool fence around your pool. My son has that around his now. So that's another thing. I want to thank you once again.
All right. I want to thank you and thank the audience who's watching.
That's
and
right.
Don't forget lifeandlawwithdebora@gmail.com. Email your questions.
That's right. And we'll see you next time. Thanks for
bye.
joining us.